Otherwise, the non-biological parent has no standing as a parent. Okay? If the couple breaks up, this parent will have no rights, even if this parent was the primary caretaker. So now what we should do is look at, there were two very important cases. The Deborah H. case is one of them. And the other case that was very significant by the Court of Appeals is the matter of HM. And this is whether parents in same-sex relationships have standing as a parent. So the Deborah H. versus Janice R. case, which is the Court of Appeals in New York State 2010, concerned the parental rights of a same-sex partner who was not the biological parent and who had not adopted the child. In December 2003, respondent Janice R. gave birth to a son conceived through artificial insemination. The month before the child's birth, Deborah H. and Janice R. entered into a civil union in the state of Vermont. Although Deborah H. repeatedly requested that Janice R. consent to a second parent adoption, the latter withheld consent. Deborah H. brought on a proceeding to obtain joint custody and access rights, contending that she was entitled to relief because she had stood in the role of virtual parent. She asked the court to overrule its prior decision in matter of Allison D. versus Virginia M., which held that only a child's biological or adoptive parent had standing to seek visitation against the wishes of a fit custodial parent. So the Alice D. case, denied same-sex parents the right to have standing to sue for access to children that they raised together. But now we have the Deborah H. case. And these are both by the same court, the highest court in New York, the Court of Appeals. Deborah argued that equitable estoppel should preclude Janice from denying Deborah's parental status because Janice had allowed Deborah to stand in a parental role. So the concept of equitable estoppel means, in legal terms, is that you are now allowed to put forth a claim if you've recognized the opposite of that claim previously. So in other words, Janice R. had recognized Deborah as a parent and now was trying to deny the right. So Deborah was trying to say that she's equitably estopped from stating that Deborah H. should not be recognized as a parent because Janice had let her stand in the parental role. She further claimed that it was in the child's best interest to establish her parental rights because the standard in custody is best interest. But in order to get to a best interest standard, you have to be recognized as a parent. So when you do general custody cases, parents are recognized, and then they go to what's the best interest of the child. So even if two same-sex parents are recognized as the parents, just like in a heterosexual couple, that doesn't automatically mean who gets custody or who gets access or what those arrangements should be. It depends on the state law. Some states have a presumption of joint custody. Other states do not have a presumption of joint custody. Some states use a best interest of the child standard, and other states have expanded the definition of parent, not even whether it's same sex, but more into whether you stood in the role of a primary caretaker, and they list various factors, okay? So this is a very changing field. Today, we are in the 21st century. And what is the definition of a family? What is the definition of a parent? What is the definition of a child? Is constantly changing, okay? There are many different types of families today. We have married families. We have unmarried families. We have domestic partnerships. We have people who just decide to raise children together. but take on parental responsibilities and obligations. We have children who have always been raised by grandparents, by siblings, or by people they did not have any biological connection to. And now we have new areas, which I will discuss today as well, where embryos are created, eggs are frozen, sperm is donated. That'll wake you up at 4 o'clock. And basically, creation of children outside the womb or in a carrier, but has no genetic material of that carrier. There are many definitions of family. In Scandinavia, for instance, less people are getting married. They're doing parental contracts. That's what they're doing. So the world is changing, and America is growing up with all of these changes. The same-sex LGBT debate in marriage is just one part of the changing family debate. And that's where you're getting the push-pull. You're getting the fear factors. You're getting the scientific factors. Technology is changing the family. Culturally and socially, the family is changing. Mobility is changing the family. People are much more mobile. They move more. There are families that are done long distance. Skype has changed custody arrangements completely. So this all affects same-sex marriage issues, and it affects family law issues, okay? You also have the issue of people living longer because of medical advancements. So one marriage may have sufficed because people only live till 50. Now the average age is in the 80s. Many people in the future will live to 100. They may not be one spouse. In America now, over 50% of the marriages end in divorce. And also with special needs children, this is another entire area, but it definitely affects same-sex marriage as well, is that there are many children who are considered special needs children. There are many diagnoses of autism, of psychological diagnoses, ADD, children who may need help beyond the age of 21. How do we deal with these children? Many of our child support laws only go till 18 or 21. 29 states have child support laws beyond 18 or 21 if a child has special needs. This also has to be looked at in the same-sex family. If there are special needs children, how will that be dealt with? And are they recognized as a parent to even provide support? Will these issues go into prenuptial agreements? Okay. America has cyclical marriages. We see people getting married second and third times. How are the children protected? Will same-sex marriages go in this development as well? Will they go will the same-sex couples who have waited years for the right to marry, will they stay in marriages longer? Or will they also follow the American society and get divorced as well? And as much as divorce as we see, will there be then second marriages and third marriages? So this is the changing family in the 21st century. I often say it's like, I feel like it's breaking up with Margaret Mead. I feel like as a matrimonial practitioner, you're breaking up with Margaret Mead, the anthropologist. So it's an exciting time to practice same-sex marriage law and family law. You're looking at psychological issues. You're looking at cultural issues. You're looking at political issues. You're looking at scientific issues, technological issues, financial issues, legal issues, and political issues. Getting back to the Deborah H. case, the court adhered to its determination in Allison D. and held that in the absence of a biological parenthood and in the absence of adoption, New York law refuses to recognize parenthood. Unless standing is established, the court does not reach the equitable estoppel issue, nor does it go to a best interest analysis. However, they still found that Deborah H. had standing. Can anyone guess why? It's an issue that we talked about earlier, called comedy. Because the parties had established a bona fide civil union under Vermont law, and because Vermont recognizes a civil union partner as a parent of a child born to one of them during the union by means of artificial insemination, the court held that New York should afford comity, thereby ushering Deborah over the standing threshold. So they found that Deborah H. had standing because they had a civil union in Vermont, and New York recognized out-of-state unions. And thus, they did not have to get to the issue of whether you need to be married, or can same-sex couples who are not married or who did not adopt but hold themselves out as parents will be considered as a parent in a custody case, because here they had the issue of comity. There was a legal union in Vermont, and therefore legal unions, you're presumptively the parent. So then the matter was remitted to the trial court for a best interest determination. Now, a second case came about called Matter of HM versus ET, okay? And this was also in 2010, the Court of Appeals. And the Matter of HM versus ET presented similar facts, though in the context of a support proceeding. HM gave birth to a son conceived by artificial insemination in September 1994. Her partner at the time, ET, was present at the delivery. The parties shared expenses associated with the conception and birth of the child. Both parties participated in the child care until 4 months after the child's birth, when ET ended the relationship. HM moved to her parents' residence in Montreal with the child. Although ET provided some monetary contributions, and we're not dealing with aliens here. We haven't gotten to that issue in family law yet about extraterrestrials. So basically provided some monetary contributions for the child's care. In 2006, HM filed what's called a UIFSA petition. That means an interstate and also sometimes intercountry petition for child support. So the issue becomes here, again, can a same-sex person who was held out as the parent be responsible for child support? Okay? According to the Allison D case and the Deborah H case, the answer would be no, not unless they were legally married or had a second parent adoption. The only reason it was, or that they were legally married in another state or country and then was recognized in New York or a state that recognizes out-of-state marriage. But this court went in a different direction. Without distinguishing or even discussing Allison D., the majority held that because HM asserts that ET is the child's parent and is therefore chargeable with the child support. So in cases of child support, the court held that family court had subject matter jurisdiction to determine child support with a same-sex partner. There was a dissent, and he said that the parents of a child, and he used Black's Law Dictionary, saying that the term parent is not defined in the statute, and he went to Black's Law's Dictionary, and Black's Law Dictionary, which is still the same today and may need to be changed, the Black Law's Dictionary of a child of a parent is the following: the lawful father or mother of someone in ordinary usage denotes more than responsibility for conception or birth. The term commonly includes either the natural, and by natural they mean biological, father or biological mother, or adoptive father or adoptive mother, or a child's putative blood parent who has expressed acknowledged paternity, and an individual or agency who takes on the role of parent. You know, when there are no parents and the state gets involved and there's a guardian. The dissent noted that the position taken by the majority here is inconsistent with this court's holding today in Deborah H. So there are two cases by the same Court of Appeals with different rulings. Deborah H. confirmed that New York law does not recognize one as a parent absent biological parent or adoption. E.T. was neither. The only thing that conferred legal parenthood on Deborah H. was Vermont law, not New York law. There was no comedy in the case of H.M. versus E.T. So basically, the issue will come across the states is whether a same-sex parent who is not adopted or is not married, can they have custody? Can they have access to the child at all? I mean, if there had not been comedy in the other case, would that mean that one parent who grew up with the child and who was called mommy, or in a same-sex male couple was called daddy, then all of a sudden has no access if the other parent won't give them access at all? Is that in the best interest of the child? But again, in order to have best interests, you have to have the role as parent defined. So I think the concept of what is a parent needs to be looked at and how that is defined. Carmen Saparik was the Court of Appeals judge who wrote the decision in the H.M. case. Okay. And basically, she's trying to broaden the definition of parent. She said, family court indisputably has jurisdiction to determine whether an individual parent, regardless of gender, is responsible for the support of a child. Because family court questionably has the subject matter jurisdiction to ascertain the support obligations of a female parent, family court also has the inherent authority to ascertain in certain cases whether a female respondent is in fact a child's parent. And she talks about the public policy, regardless of gender, to provide for children. Okay. Now, the dissent, there was an interesting dissent, which is probably the wave of the future. Okay. So he concurred in the decisions, right? Judge Smith, he concurred in the decisions about giving Deborah H. standing and also recognizing the parents of HM and ET as both responsible for support. But he said that it's time to depart from the definition of parent as just male and female, okay? That basically what he said is, he only was talking, it was interesting, he only was talking about lesbian couples that used artificial insemination. He said in this particular group of cases where both women decided to have a child together and used artificial insemination, that parenthood should automatically be established and defined. And there should not be an issue if they're a parent because of this process. He did say that with male couples, that's to be determined in the future. So he didn't get to that yet. Again, this is 21st century because now two males can have a child together by using a carrier. And basically, the woman they use as the carrier does not even have to use her own eggs to have the child. The two males can have eggs of a donor, and then the entire embryo can be created and then inserted into a carrier. And that child, in many states, will belong to the two males, the couple. That's their genetic material. You get into other issues about the rights of the carriers and psychological attachment, but there have been cases that have said, and Pennsylvania is the most advanced in this issue, that the child will belong to the genetic parents, the male who provided, the couple who provided the genetic material and not the carrier. There are other cases, though, that if they use the eggs of the carrier, that carrier may have rights. There has not been, and this is what I would be interested in, there have not been psychological studies, as far as I know, about the psychological impact of these arrangements on the carrier afterwards or on the intentional parents. But that is something to be looked at. So, as I said, Judge Smith went further and said, no, it should be a bright line test that if two women have a child together using artificial insemination, that should be considered parents. And therefore, they have standing for custody and for child support. Now, he said there are certain states that create not such a bright line. And the definition of parent, Wisconsin is very advanced in this area. Wisconsin uses various factors to look at if a parent-like relationship has been established. And they do not look at if there's a biological relationship. It does not even have to be a same-sex couple. It could be anyone who has acted in the role of a parent. If they have been acting in that role, they could be considered a parent for custody or child support purposes. So the Wisconsin Supreme Court decision was in re custody of HSH-K, and that was decided in 1995, quite a while ago, which permitted a party to establish a parent-like relationship by providing 4 elements, including such things as significant responsibility for the child's care, education and development, and a bond-dependent relationship. So that's another whole advancement about what is a parent, if you look at that. But what Smith said was, to put a large and growing number of our state's children in that status seems wrong to me. Each of these couples, wrong to me being that they don't have both their parents, just because they were 2 mommies or 2 daddies. Well, he was talking about mommies in this case. Each of these couples made a commitment to bring a child into a 2-parent family, and it is unfair for the children to let the commitment go unenforced. Nor can it be said that adoption by the non-biological parent, an option available, is an adequate resource. For adoption is possible only by the voluntary act of the adopting parent with the consent of the biological one. So the problem becomes, what if one parent agrees to adopt, but the other one doesn't want them to adopt? That's what happened in the Deborah H. case. Deborah wanted to adopt, but Janice didn't want her to. So that's why she couldn't have standing through the adoption process. That's why you do have to look at the next step about what is a parent even if you have not adopted. Okay? Okay. So now let's talk about surrogacy, which I hinted at a little while ago. Okay? Types of surrogacy. Surrogacy affects same-sex couples, particularly male-male couples, okay? Because they cannot carry a child. Well, not yet in science. Types of surrogacy. What time is it? Okay. So, types of surrogacy. Traditional is the surrogate is both the legal and biological mother. Gestational, the surrogate is neither legal nor biological mother. Courts have held that a genetic mother who uses a gestational carrier can have her name placed on a birth certificate without an adoption proceeding. Okay? This was in the case of TV versus New York State Department of Health, August 9, 2011, Appellate Division. Okay? We have a few more minutes. So we'll end on the surrogacy. Courts have held that a true traditional surrogate can keep the baby. In the matter of Baby M in New Jersey, that agreement, there was an agreement for the surrogate mother to get $10,000. Many of you may remember the Baby M case. And when she had the baby, though, the agreement became unenforceable and a payment was a violation of adoption laws. States vary whether the gestational carrier can keep the baby. Okay? In Pennsylvania, the court ruled in 2006, JR versus DB, that genetic father was the sole parent and gestational carrier had no standing to seek custody. In New Jersey and Massachusetts, biological parents had the right to be on the birth certificate without the need for adoption. Okay? So basically, in these type of arrangements, we're the surrogate. You have to look at if there's a contract, you need a contract between the parties. You need a medical release for the carrier. You need birth order to place the intended parents on the birth certificate. You may need insurance of the carrier for IVF, for pregnancy and the child, and you may need an escrow account established to pay the carrier. So these are the contractual issues that get involved. Both the carriers and the intended parents should have lawyers, okay? And basically, you need strategies. Now, that's the surrogate issue. The last issue I want to address today is about prenuptial agreements. Many same-sex couples, until the laws changed at the federal level, and because I told you the differences that are involved, will need strategies to protect same-sex couples regarding health care, real estate, and inheritance. So basically, with prenuptials, the main things you have to consider in a prenuptial agreement is whether you're going to make claims and waivers about real estate and equitable distribution, about a choice of law. Are you going to have the law used where you live or a different state? Basically, how you're going to deal with the tax consequences, life insurance, commingling, parenting attentions with adoption. These are various factors. So, and you have to do the tax planning. So in closing, when a same-sex couple comes to you for advice, whether they should marry or not marry, you will need to look at state law, federal law, and the recent Supreme Court decisions that may or may not happen in the next few months, and whether that will take on. And you must also advise them about prenuptial agreements and tax issues and children issues, and most importantly, about portability issues. What happens if they move? Thank you so much.